Welcome, everyone. It's great to have you all here at this OAPI Council's panel discussion on the European Commission's leaked draft regulation on essentiality checks and SEPs. My name is Axel Ferrazzini. I'm the Managing Director of OAPI Council, and I'll be the moderator today. As you may know, OAPI Council is a not-for-profit research organization focused on the link between IP and innovation. We identify the most relevant topics and produce empirical research in collaboration with academics. The OAPI Council website has a dedicated webpage on SEPs and essentiality checks that you can access directly from the homepage. Just go to oapicouncil.com. As you might know, members of standards development organizations typically make their patents essential to a standard essential patents, or SEPs, available on fair, reasonable, and non-discriminatory terms and conditions. FRIEND is commonly negotiated by the parties in bilateral good faith negotiations. In the few occasions where parties cannot agree on FRIEND terms, we see FRIEND disputes. This means parties may end up in litigation or, if both agree, in mediation or arbitration. Today, we will discuss the leaked draft regulation proposal from the European Commission on SEPs. We will also assess possible implications from intellectual property law, constitutional law, and competition law perspective of the proposal for regulation on SEPs. It is my great pleasure today to welcome our three panelists, eminent professors teaching in highly recognized universities in Germany, Italy, and France. Let me introduce Professor Mary-Rose McGuire, who is a professor at University of Osnabrück in Germany. She is also chair of civil law, intellectual property law, and German and European civil procedure law, as well as the executive director of the Center for Business Law. Then we have Professor Laurent Manderieux, who is professor of intellectual property law at the Bocconi University in Milan, in Italy. He is a member of the Directorate board, Bocconi LL.M in Law of Internet Technology, as well as the chair of the European IP Teachers Network and coordinator of the Transatlantic OAPI Academy. And we have Professor Nicolas Binctin, who is a professor at the Faculty of Law of the University of Poitiers, Paris 2, and visiting professor at Bocconi University, Alicante University, and at the African Organization of Intellectual Property. He also manages the Master Program on Research and Innovation, Development Law, and Master Program on IP Law. Thank you for having accepted this invitation and for being here today. To kick off this discussion, I would like to start with the following question. And at any time, if you want to answer, please do so. To support the need for regulation, the European Commission has argued that European courts have been ineffective in addressing disputes over FRIEND terms. The proposal even mentions the unavailability of dispute resolution procedures suitable for resolving FRIEND disputes. Do you share this view? How competent have been European courts in addressing the FRIEND disputes, in your opinion? Mary-Rose, should you want to start?
Sure, thank you. I've read this unavailability of dispute resolution, and it took me by surprise. We can discuss whether FRIEND litigation is perfect, but we can't say it's unavailable. We see we have different routes of enforcement or also bringing FRIEND disputes before courts. We have patent litigation, which necessarily will imply FRIEND arguments, but there's also arbitration. So I would say there are manifold ways to actually litigate FRIEND disputes. It could be either before a state court or before an arbitration. We see that the parties use the court system. We see judgments in reasonable time. So yes, there may be room for improvement, but I think the statement it's unavailable is just not justified against the current practice.
Thank you.
I think the Huawei decision has been well implemented by the courts in Europe, and if there is some forum shopping based on this case, is maybe not according to the quality court in Europe, but mainly in front of the jurisdiction strategy of the player in the front system.
Indeed. In this situation, the proposal of the Commission is no doubt premature in the sense that there are dispute resolution mechanisms at courts or advanced dispute resolution mechanisms that have proven to be valid. There are always, as mentioned by my colleagues earlier, ways to improve such mechanisms, but to say that the mechanisms are unavailable is not the right approach and the correct approach.
I would like to add, even if there is a problem or perhaps room for improvement, I am surprised at the time of this proposal because all of Europe is awaiting the Unified Patent Court to open its doors and start. And we all expect that this will be a very efficient and high quality dispute resolution mechanism. And so it would be natural to see and await this new system starting. And if then we see after a few years that the workload is too high, it takes long, whatever, then we could think of how we further improve the system. But I'm worried that this is not the right moment to take action.
If I may add, I would totally share this comment. Again, the proposal is premature, or the draft proposal is premature, in the sense that we need to wait a few years until understanding how the UPC is functioning and whether new problems arise and whether the workload of the UPC creates a problem in this area or not.
Very good. I'm actually just trying to move on because to provide a solution to deal with friend disputes, more efficiency, as I say, more efficiency than courts, the European Commission proposes to create an administrative body within the EU IPO based in Alicante. What are your thoughts about this? Maybe you, Laurent, you would like to start.
With pleasure. I think in academia, in the business world, in consumers world, there's a major esteem for the work performed by the European Union Intellectual Property Office located in Alicante. However, there is no current competence of EU IPO on patent matters or patent-related matters. In case there is a need for an institution for handling this matter, is it the right place? How long could it take to EU IPO to create authoritative institutions to handle the matter? This is a big question mark. The executive director of EU IPO had declared not long ago that the institution has no competence on patent matters. Of course, nobody prohibits that this competence be stopped, but this would take an immense lapse of time. In addition, is it really necessary to do it so? Okay, EU IPO handles with third countries cooperation programs that involve activities of patents that are delegated most of the time to the EPO. But this is in a sector that is very different than the one we are considering. And there we are facing an issue of competence building and of course, opportunity of doing it so, and costs for the European taxpayer.
I think that the European Intellectual Property Office, without doubt, is a very competent authority. But when it comes to SEP and FRAND, we have to say that standardization from a legal perspective is very straightforward. Everyone knows how it is supposed to work, but it's very complicated in practice because so many people are involved. Now, when it comes to patents, we have a highly renowned European Patent Office, and we have the standardization organizations. And what I think is very surprising is that all the information we need is sitting either in the patent register or with the standardization organization, whereas the EU IPO of itself has no information. And that's what we take from this draft. A lot of duties or obligation posed on the stakeholders are to provide information to the EU IPO because they don't have this information of themselves. So they want to know which patents are included in the standards. The standardization organization knows already. They want to know, is the patent valid and enforced? The register knows already. So why do we put in a new third prominent player which doesn't have knowledge of its own at the moment? They can build up resources, but at the moment they don't have knowledge of their own, and they have to draw the information from players we have already. So if we want to foster transparency and standardization, I think it would come more naturally to put the competence to one of the existing players instead of trying to create a new one.
Yes, and maybe we can also see in this proposition of the Commission a deep evolution of the Commission in front of the IP, and the Commission promote an administrative regulation of the IP. It's already the case for trademark, it will be the case for design right, and we can see that there is already some the same dynamic for some state members, and we want to have an administrative regulation of the patent. So the fact is that it's hard to combine a global qualification of IP as a ownership right, a private ownership right, and an administrative regulation for an ownership right. And in front of that, we can imagine that a new dynamic for the IP can be identified in such a proposition, which is IP less and less an ownership right and just a kind of administrative authorization which can be adapted or changed by an administrative decision. And in front of that, I think such a proposition have a deep impact on our global analysis, global qualification of the IP law, and it is really important to put it on the table because step by step we try to refine the qualification of the IP, because when the IP is an ownership right, we have to respect the ownership and the private ownership, which is one of our fundamental rights. Can we imagine that we can decide how you have to share or rent your home just through an administrative body decision? I think it's not right.
Then to follow up, some have suggested that the draft SEP regulation is circumventing, to a certain extent, the Court of Justice of the EU, national courts, as well as the newly established Unified Patent Court. Do you have any thoughts about this? And what are your views regarding the constitutionality of the proposal?
Thank you for the question. It's quite complex. I'm not sure that I'm able to answer to the constitutionality aspect of the question, but I think we must clearly distinguish between the European Court of Justice and the UPC. The first is an EU legal body and not the second. So in front of EU regulation, we may imagine that the competence of each court will be different when it just focuses on patent, and the other one maybe will be able to give the interpretation and control this new regulation. For the European Court of Justice, the decision of the new administrative body, which can be law according to the regulation, the decision will be covered maybe by the European Court of Justice competence, which can interpret and control this administrative decision. But of course, if there is some discussion about the quality of the patent, the UPC will be in the area to discuss this part. And we can also imagine inside some portfolio of SEP, patents may remain under national patent law with the opt-out solution, for example. And in that case, the UPC will not be able to discuss the quality of the patent, so it will be under the national court, and we have to combine it with the body who control the financial and then the front aspect of the license. So at the end of the day, with such a new regulation, we can imagine that we have to combine more or less 4 legal different systems together: the national, the EPO, the UPC, and this new European administrative body. So it can be just a nightmare for any user of the patent system. Just imagine that you have a co-ownership on some patent in a portfolio. The co-ownership is covered by national law, whatever is the UPC, because the UPC is not with competence for this part of the patent law.
And a nightmare and a cost.
I would also,
if there is no doubt, and you can have also, of course, this administrative body which is involved in a case. I don't think that such an academic hypothesis, a co-ownership, is something far from the reality, and we can imagine the difficulty for the user of the legal system to organize something in front of that.
Mary Rose, you wanted to add something?
yes, you've raised the question whether it's an issue that it's an administrative body. And actually, when you start reading the regulation, you first get the impression it's all about transparency, and it's basically a service provided to the SEP community. But then the further you get on, it seems that the Commission was worried that not everyone would take interest or comply, and then it turns from a service to an obligation. If you don't register on time, if you don't adopt, then you may have other disadvantages in going before court, for instance, because you're blocked for a while. And I think that's a real problem in this regulation. It is somewhere in between an administrative body and a quasi-court, because if you want to have an efficient remedy, you will have to wait. You have to ask the administrative body before you go before a court. But then this administrative body doesn't provide the same standard of procedure as a real court would have. So it's somewhere stuck in between, and I think this just does not live up to our expectation to fair proceedings, to be heard, to have your confidentiality preserved, to have your fair hearing, independent judges. So it's somewhere in between, and I think whatever is coming would really have to make a decision. Is it just a service provided to the SEP community, or is it a court procedure in place of what we have? But at the meantime, it's in between, and I think this is very unsatisfactory.
This is indeed very concerning, which leads me to the following point, because according to the proposal, the SEP owners cannot refuse to license their patents to a party who is willing to agree to friend terms. This seems to contradict commercial practice to license to a single point of the value chain. What will be the implications of changing the commercial practice, in your opinion?
This is also something which was worrying me when I read the draft. It's like a one-size-fits-all solution for all types of industries. And when we look at industry practice, the industries for the different sectors, for historical or traditional reasons, they have organized themselves well, but in different styles. And now we would force one functioning system from one functioning in one sector on all the other ones. Now, if everyone asks a license and we have industry sectors with manifold players, then we need so many license contracts and so many license negotiations that the transaction costs are just excessive. So I think it is, if there is a real problem in a specific sector, then perhaps it is worthwhile tackling this issue, but it would be very detrimental and a disadvantage in comparison to what we have now to impose a system on everyone and even on those sectors where it is functioning very well.
Thank you. Anyone willing to add something?
Yes, maybe we can add that we already have some legal license in IP system. We can imagine legal license for copyright or legal license for producer rights. But in those two cases, we also have collective management organization, which discuss the revenue linked with those legal license. And of course, the collective management organization is supported by the owner, so by the owner or by the producer. In the present project, I think the Commission has an idea, but has no tool to organize and refuse to have a global analysis of the market. So we just try to find a quick answer for consumer and price, but we are missing the global organization, the global balancing system of a market, and that can be a problem. Because without any global analysis, without any global comprehension of the system, it will be difficult to have such a legal license for patent, and of course, in the case of SEP too. So such a regulation may have a deep impact on the EU market, but maybe not as the Commission wants. And I think we must conclude again that we can feel or we can see the limited ambition of the European Union in front of the patent law. We refuse to have EU patent, and then we try to create some small elements for small tool to regulate something which we refuse to have clearly inside the EU legal scope. And it is clearly a problem again with this kind of license.
I totally share my colleagues' views, and the one-size-fits-all there, though corresponding to international treaties and to EU practice on compulsory licensing, brings a problem of lack of sufficient market analysis, sector by sector, and brings an issue of effectiveness. In other words, once and again, the draft proposal needs to be further reviewed in this part of it.
Okay, yeah, that's good comments. Thank you. But moving on, another element that created a lot of reactions is the following: the draft SEP regulation imposes limitations on the patent holder's rights. An interesting detail is that it will apply to the entire patent, including essential claims and non-essential claims. And in particular, it will require the parties to engage in a conciliation process that will last 9 months. Only after this period, the patent holder will be able to exercise its rights in court. How appropriate and proportionate is it to freeze the patent holder's right for 9 months, in your opinion?
Well, I think that this is not a great move. The European Commission's tentative draft proposal introduces a concept that may be not working very well, and above all, that leaves doubts on whether European Commission, and in particular DG Trade, could defend it in case of critics or attacks at the World Trade Organization. Article 28 of the TRIPS agreement that was recently invoked by the European Commission in a case against a major non-OECD superpower recently, clearly enough, would probably not permit such provisions. So there it is in the interest of the EU, but also of OECD countries to probably pull back on this and adopt a more nuanced approach.
I believe also from the perspective of civil procedure and fair proceedings, it is a very worrying. The whole regulation sets out to make everything more efficient. Now we have a 9-month procedure upfront, which is supposed to put the court litigation on freeze. But then there are courts in Europe which are actually able to litigate a full patent infringement case within 9 or 10 months. So it will double the time. And I think it's particularly worrisome that there's no exception for interim relief. Obviously, if a patent is infringed, the first turn usually is to ask for interim relief in order to freeze the market and not freeze the litigation. Now, the regulation has some rules on parallel proceedings, but they only focus on parallel court full litigation, and they don't lose a word on interim relief. Now, if interim relief would be also blocked, this really would be harming our principle of effective remedies. I think this is just not a workable solution.
Yes, I agree with my colleague, and I think we have to check the compatibility with TRIPS. We may add to that, we know that it's possible to have adaptation of ownership in front of general interest, in front of market adaptation. It has to be proportionate, and it has been deeply discussed with the plain packet regulation for IP, for tobacco industry, and we had a lot of discussion about proportionality and ownership, and general interest. So we know that we can adapt maybe the ownership system based on the general interest, but we don't know if we are in the right case, and we don't know if those 9 months are clearly in shape with this kind of goal. So I'm not sure that it is the right solution at the right moment.
But you know, there is a next step in this entire system, which is the regulation also includes provisions regarding the so-called aggregate royalty for SEPs. Especially, it provides that contributors to a standard may jointly notify the aggregate royalty for the SEPs included in a given standard. So, in your opinion, what will need to be considered in this joint notification under competition law?
Thank you. That's a nice question. And it's quite a funny point because it's a very, very classical discussion, the combination between patent law in front of standard and competition law, and everything comes from that point maybe. But we know that we have to create a cartel to be able to develop standard, and we know that in front of the regulation law, the competition law, the standard, the cartel is not something very nice. So we have to be sure that the cartel can be included in the paragraph 3 of the Article 101 of the EU treaty. And we never sure that we are able to reach the criteria of the paragraph 3. And we know that according to block regulation for co-development technology, one of the limits of the block regulation is the cooperation in front of the price. So in that case, we are clearly in conflict with the block regulation, which come from the European Commission too. So how we can combine this regulation with the block regulation, have no idea, of course, because they are clearly not in the same idea, of the same mood. And we know that if there is cooperation between parties in a standard on the price, it is clearly something which cannot be relevant in front of the Article 101. So such point is something strange, and we imagine that maybe the Commission just want to discuss or open a discussion, and maybe the Commission has also a difficulty to accept that standard is something which can be good for the market, but standard also has deep impact on the market dynamic in front of cooperation between parties and in front of competition.
I would have two very short points to add. One is a lack of respect for trade secrets. If the different competitors have to share information in order to notify on an aggregate royalty rate, they will have to share information to make their case that they get an adequate part of it, which they don't want to share. That's a real issue. And the second is this whole setup that the parties are obliged to tell this new competence center what an adequate aggregate royalty rate would be. It underlines this inconsistency we mentioned before. The European Intellectual Property Office at this point has no own knowledge on the patent system. They have to draw the information from other people. And when they look at the price, they thereby acknowledge that the parties know best. They are the only ones who know how much investments they made, where the patents are and how they are implemented, what the cost structure is. So it just undermines the idea of a competence center if they don't have competence of their own, but draw on the standardization organization, the European Patent Office, and the stakeholders.
Laurent, do you want to add something?
I totally share my colleagues' views.
Okay, very good. But just to add on this specific point, it is also possible for at least 5% of all the contributors to the standard and or 5 implementers or potential implementers of the standard, that is what the leaked draft regulation is saying, to request the agency to issue for a non-binding expert opinion on an aggregate royalty. So it means that it may look like a bit different from the first part that we just discussed, but what are the practical consequences of this second approach, in your opinion?
Oh, I think that the previous remark may be applied again at that point, but we can also add some other point, and of course it's look complex to be able to implement such a possibility. 5% of contributor is a very low level of contributor, and we know that 5% contributor is not 5% of the patents, because each contributor is not able to bring the same volume of patent in the standard. 5%, 5 implementers is also very low, so it's a kind of very easy tool which has to be able to put in action. That's the first point. The second point, and I think it's more relevant in our case, is that the evaluation of license rate is something which is really complex. It's not just a question of a piece of bread. It's something which is deeply involved in a global strategy of a company, according to the investment, according to the business model of the company, according to the perspective of the company. And to be able to identify a license rate, we must be able to use all those criteria take into account. So, of course, there is problem with secrecy. There is problem with appreciation of the company strategy. Do we have to imagine that this expert opinion can discuss the legitimacy of strategy of a company? Can we have to imagine that the whole company must have the same business model and the same strategy to be able to have such aggregate royalty appreciation? Of course not. Or it is the end of a free market. We just have a kind of communism organization with a single price coming from a kind of political decision. And then last but not least, what we have to do with non-binding expert opinion is a kind of information, an information which is based on approximation without any deep legitimacy. And do we have to imagine that non-binding opinion will be the base of a discussion? Can we imagine that this non-binding opinion will influence the judge in case of conflict between the party? It's something very strange. And the last point is that we may have different rate according different category of. So this non-binding opinion can be for a single category of clients, single category of user of the standard, but maybe no for all kind of user of the standard. And the cost would be just amazing because you must, it's a very complex job to be able to identify and aggregate royalty rate, which is proportionate and which respect the interests of the owners and the interests of the user. And last but not least, we have to discuss then how we share the money between the owner, which is another point in that case. So we will have a lot of discussion on that in the future for sure.
I would also be worried about the number. So 5 implementers or 5% is a very low rate. And we all know that there are fierce negotiations going on in the France area. So I could easily imagine that 5 implementers just tell the other side, we want this in this share or this in this friend rate. And if you do not agree, we will make sure that there will be a procedure before this new competence center, which will cost a lot of time and some money. So this is just a new means of leverage in the negotiations. So it doesn't make it more efficient. It makes it, it's a new potential hold up in a very different situation.
I would further add that these, to be consistent with what my colleagues mentioned, this red tape provision basically is also favoring very much non-European or basically non-OECD new entrants who in this way could get access or push to lower the threshold of standards in a sense that is not necessarily favorable to European innovation, the European innovation system.
Yes, if I may add to Laurent's point, we can imagine that in front of the European Commission opinion, we have very limited volume of contributor in the EU market, just implementers. So we try to protect the implementer and at the end of the day, the consumer, but nothing is organized for the contributor. And it means that we are already out of the market, out of the business for technological standard, which is a very bad news for us.
Indeed. Which leads me to my last question. So the European courts have been playing an important role in developing the jurisprudence on SEP-related disputes so far. And they had a visible influence on decisions in foreign jurisdictions. Do you foresee any change after the adoption of this regulation? And if so, do you expect European courts to win or lose in their relevance?
I think it's quite obvious. In particular, this freeze is very concerning because it means that people have to wait and go through an additional procedure before they can enforce before a court. And this requirement can only bind European courts or the Unified Patent Court, whereas you could go and litigate as you always have in every other third country. So it would naturally incentivize parties to go to third countries or to go to arbitration. And both would be detrimental in order to foster transparency and efficiency in the market. We have highly renowned working patent courts in Europe. We are all looking or waiting for the Unified Patent Court. And we put out an incentive to go to third countries or to go to arbitration. And we all know that when arbitration is effective, but it is costly. And of course, the information which gets back, which can be used by the market and society, is even less. So yes, the European courts and the newly set up Unified Patent Court would lose a major part of these disputes. And I think it would be to the detriment of everyone.
Thank you. Anyone willing to add something?
Yes, I think we can see that the European Commission and maybe the European Union is missing the 21st century patent challenge. So we refuse an EU patent, we refuse an EU jurisdiction for patents, and then we try to build some kind of pure technical administrative solution for something which is really important for all of us, the SEP regulation and the front system. And we just create a very complex legal environment, which can be interesting for global players, but not for SMEs, not for the European market, not for the innovation in the European environment. So we are missing a lot of goal, and we just want to have a quick, simple solution far from the reality of the legal environment. So I think we must have a global reflection on patent in the system and rebuild our patent system in the EU.
And I would add that the issue relates to patenting, enforcement, and circulation of rights. And in this very respect, the issue of circulation of rights cannot be detached from the other contexts. And this is why it is wise to further reflect before launching this draft proposal in the arena, a draft proposal that has weaknesses in the sense of competition law, consumer law, trade law, and that can have a negative impact on innovation in Europe and on the position of European innovation in the worldwide environment. So that's why it's interesting it's useful, interesting, important to wait, consult, and construct in an organized way appropriate replies, if necessary, to questions that are not well established and therefore not well replied to.
Thank you. I think that will be the wise words of the end, and I would like to thank you, Professor McGuire, Professor Manderieux, and Professor Binctin for providing us with such an insightful discussion. I have to say that your expertise and knowledge on this very complex topic were truly valuable and greatly appreciated. So I would like to thank you all for joining us. And if you want to say a last word, it is the moment. No? All good?
Thank you.
So thank you again.
Thank you.
And looking forward for the discussion. Goodbye.
Bye.
Bye.